At 6:12 a.m., the shoreline was 30 feet farther out than it had been the night before. I stood where water used to meet stone and listened to nothing. No intake hum, no low churn from the circulation pumps, just wind sliding across exposed mud already splitting under the August sun. The intake towers, usually waist-deep, rose naked and streaked with silt. $8 million of engineered storage reduced to a shallow, stagnant basin in less than 72 hours. My phone buzzed while I was still calculating loss in acre-feet. Certified notice. Homeowners Association. Not to lied water retention structure. Community drainage compliance enforcement. They'd opened the auxiliary floodgate, tied to the downstream culvert without a court order, without state notification, without asking a single question. They thought they were draining a pond. They drained a regulated, state-permitted private reservoir tied to commercial water rights. By 9 o'clock, the HOA president called. Polished voice. Measured. She informed me my water feature violated updated watershed guidelines and had been corrected. She sounded proud of it. I told her I'd review the documentation. Then I hung up. But let me back up. 12 years earlier, before the subdivision crept east, and before the HOA redrew its governance map, that basin was raw pasture my father used for rotational grazing. He bought the acreage in the late 70s for one reason: water access. The underlying rights were adjudicated long before anyone installed decorative mailboxes or uniform fencing standards. When I built the reservoir, it wasn't cosmetic. It was engineered, state water authority permits, environmental impact clearance, spillways rated for 100-year storms, reinforced embankments with compacted clay core, metered outflow system tied to downstream compliance monitors. Everything documented, stamped, recorded. The numbers weren't theoretical. $3.2 million in excavation and composite lining, $1. $8 million in pump stations and irrigation distribution. Roughly $2 million in structured commercial water contracts. The rest embedded in infrastructure, tax basis, and increased land valuation. It fed leased agricultural acreage and supplied a small regional bottling partnership under fixed volume agreements. It moved through meters, not lily pads. By the time the HOA expanded its boundary overlay, the reservoir had been operating lawfully for nearly a decade. Ownership predates administration. Water rights don't dissolve because a board updates its handbook. The citation referenced Section 14, 3B, of the revised community drainage standards adopted 2 years after my reservoir was completed. It mentioned runoff misalignment, an aesthetic nonconformity with neighborhood watershed design. Polished language, confident tone, completely detached from jurisdictional reality. Without a court order, the board authorized a contractor to access the auxiliary floodgate, where my discharge channel intersects a culvert running beneath HOA common property. The easement allowed shared drainage flow, nothing more. Still, they treated it like a master valve. Over 72 hours, the gate was opened incrementally. Millions of gallons redirected into downstream retention canals designed for seasonal overflow, not controlled release. I received the notice after the basin was already collapsing inward. There was no confrontation, no raised voice. I launched the drone and recorded the exposed embankments, pulled digital logs from the automated gate monitor, compared pre- and post-discharge flow meter data, captured the contractor's truck plates and license number. They believed they were enforcing landscaping standards. They had, in reality, interfered with a permitted water control structure under state authority. On paper, it looked like compliance. In statute, it looked like something else entirely. Anger is expensive. Documentation is not. By mid-morning, I had 3 calls scheduled. First, the State Water Resources Division compliance officer I'd worked with during original permitting. Second, my environmental attorney. Third, the hydrological engineering firm that designed the spillway system. Within 48 hours, we had clarity, the reservoir's designation, private regulated agricultural storage, the gate opening, unauthorized interference with licensed water rights. the downstream surge, probable violation of sediment containment thresholds. The engineer was direct. They treated it like a decorative pond. It wasn't. I drafted one letter, no threats, no dramatics, a formal preservation of evidence notice, demand to cease further interference, request for contractor agreements, internal communications, and board authorization records, certified, time-stamped. The HOA's council responded 3 days later. Board acted within its enforcement authority over standing water features. Standing water features. That phrase told me everything. They still believed this was landscaping compliance. They hadn't realized they'd stepped beyond handbook governance and into state water law, where authority isn't voted on monthly, it's recorded. The hydrology audit took 10 days. What it uncovered changed the posture of the entire dispute. During peak rain events, my reservoir's regulated overflow acted as a buffer for the subdivision's stormwater grid. The controlled release reduced downstream surge pressure before water entered the HOA's retention canals. It wasn't charity. It was physics. The system had been modeled that way when the expansion was approved. By draining the basin, they didn't just remove stored water. They stabilized their own flood mitigation assumptions. Then my attorney found the easement language recorded with the county. Non-interference with upstream impoundment operations. Clear, unambiguous. Filed years before the current board took office. No one had reviewed it. The contractor, under deposition notice, admitted he never checked state permit status. He followed board instruction. That's when insurance entered the conversation. The HOA's policy excluded coverage for intentional regulatory violations. What began as refill a pond was now exposure for breach of water rights, commercial disruption, environmental penalties, and potential fiduciary negligence. I didn't issue statements, didn't attend the next board meeting. Silence, when documented properly, becomes leverage. Numbers remove emotion from a room. My accountant compiled the first report within 3 weeks. 1. $4 million in projected agricultural loss tied to irrigation disruption. $2.1 million in contractual penalties from the bottling partnership's fixed volume shortfall. $600, 00 in sediment remediation. Downstream after the accelerated discharge. $800,000 in structural stress assessment and reinforcement to prevent embankment cracking during refill. Add diminished asset valuation during the 14-month projected refill window, because regional allocation schedules don't bend for HOA mistakes. The engineers confirmed it under oath. Full restoration would require phased replenishment aligned with state distribution quotas. Then the state agency formally opened an investigation into the unauthorized release. That's when the tone shifted. The HOA's attorney requested additional time to evaluate jurisdictional implications. Translation: they were beginning to understand. A board meeting transcript surfaced during discovery. The president's voice, steady as ever. We had authority over standing water. But regulated impoundments aren't standing water. They're licensed storage. They acted confidently, just not within their jurisdiction. We filed in county civil court on a Tuesday morning. Tortious interference with contractual relations. Trespass to chattel water recognized as a managed possessory resource. Negligence. Breach of recorded easement. Declaratory judgment affirming the reservoir's protected status under state law. No press release. No neighborhood spectacle. Just stamped filings and service of process. Discovery moved quickly once the state investigation became public record. Internal board emails surfaced casual, dismissive. One line stood out from the HOA president. He can't expect to keep his private lake fantasy forever. Fantasy, that phrase mattered. It suggested awareness, impatience, and deliberate action rather than clerical misunderstanding. My attorney circled it without commentary. 2 weeks later, the HOA's insurance carrier issued a reservation of rights letter, signaling potential denial of full coverage if intentional regulatory interference was proven. Board members quietly retained separate counsel to assess personal exposure yet in mediation scheduling calls. The president maintained composure. She believed escalating costs would pressure me toward compromise. What she underestimated were the statutory penalties attached to interference with licensed water rights. Those numbers compound quietly. It was a bench trial. No jury. Just a judge with 15 years in environmental and land use law. Our hydrology expert walked through modeling projections, rainfall absorption curves, controlled overflow diagrams, downstream surge comparisons. Satellite imagery mapped the 72-hour discharge in precise intervals, blue fading to brown, acre-foot by acre-foot. A state water official testified next. Calm, unimpressed. The HOA had no authority over a permitted agricultural impoundment. None. Then came the moment that shifted the room. The judge looked directly at the HOA president. Before authorizing the drainage, did you seek confirmation from the State Water Resources Division? Silence stretched longer than she expected. No, Your Honor. My attorney introduced the email, force compliance quickly, alongside the private lake fantasy remark. The judge's tone never rose. HOA governance does not supersede state water rights law. The ruling followed weeks later. Approximately $7.3 million in compensatory damages, $2.9 million in contract losses and restoration costs, $1.8 million in punitive damages for willful interference, just over $12 million. The order included mandatory governance oversight reforms and external compliance review. No theatrics, no applause, just a written judgment restoring jurisdiction where it belonged. The reversal was complete. The insurance carrier's final position was predictable. Intentional act exclusions applied. Coverage would be partial at best. The board called an emergency community meeting to discuss a special assessment. Tension spread quickly, neighbors calculating numbers they never agreed to risk. When I stood to speak, it wasn't to escalate. I proposed a structured repayment framework, tied to reserve reallocations, phased over time, designed to prevent foreclosures or forced sales. The judgment allowed flexibility. I chose to use it. The mistake belonged to a board, not every homeowner on the street. Within a month, the HOA president resigned. No statement beyond personal reasons. A bylaw amendment passed shortly after. Explicit limitation on enforcement authority over pre-existing, state-permitted structures. External legal review required before any action affecting regulated assets. Reconstruction on the reservoir began under tighter controls, reinforced intake locks, monitored gate access, redundant flow alarms tied directly to my office and the state database. I didn't celebrate when the waterline returned. I watched it rise. Ownership doesn't shout. It stabilizes. By early spring, the basin began to look like itself again. Water crept up the reinforced embankment in slow, deliberate inches. The clay core held firm. Intake screens sat locked behind steel housings. When the primary pumps restarted, the sound was steady, low, mechanical, reliable. The kind of sound you only notice when it's been missing. I stood at the same edge where cracked mud had stretched for 30 feet. Authority without jurisdiction is noise. Ownership backed by documentation is leverage. The board's real mistake wasn't draining water. Water can be restored with time, permits, and patience. Their mistake was assuming a revised handbook, outranked recorded deeds, adjudicated rights, and state statute. Paper rules feel powerful inside a meeting room. They dissolve under the weight of law. Some boards think enforcement is power. Real power is knowing which statute governs the land beneath their feet. The reservoir filled. Contracts resumed. The neighborhood remained intact, just quieter, more careful. And if you think this was expensive, wait until you hear what happened when a different HOA tried to seize mineral rights under a retired engineer's ranch.